Good morning, everyone. I'm Matt Fruman, Ward 3 Council Member and Chair of the Committee on Human Services. Today is Tuesday, March 25th, 2025. We are meeting in person in room 123 of the John A. Wilson Building and virtually via Zoom. The time is now 11:06 a.m. and I am calling to order this additional meeting of the committee. Today, we have a quorum comprised of Ward 5 Council Member Zachary Parker, at-large Council Member Christina Henderson, at-large Council Member Robert White, and Ward 7 Council Member Wendell Felder. Today's agenda includes one permanent bill, one separately referred title of a permanent bill, 3 confirmation resolutions, and an administrative resolution. The first of the measures up is B 260046, the Emergency Rental Assistance Program Reform Amendment Act of 2025. Chairman Mendelson introduced B 260046 on January 13th, 2025. The legislation reforms the Emergency Rental Assistance Program, or ERAP, and related eviction court procedures. First, the legislation allows instead of requires judges to grant stays in eviction cases with pending ERAP applications. This provision addresses the backlog in the landlord-tenant branch of the DC Superior Court caused by the pandemic-era requirement that judges grant indefinite stays in all cases with pending applications. We all want to avoid evictions, but without a working eviction process that encourages landlords and tenants to work together where they can, the system cannot function and there are many victims. While eviction processes used to take several months, they can now take more than a year, and it sometimes takes several years. As a result, arrears frequently accrue beyond the point at which negotiation can avoid eviction. And unpaid rent has put our entire affordable housing market at risk. Unpaid rent due to affordable housing providers has increased 1,336% since 2020. Average arrears are higher in the district than anywhere else in the country, and providers can no longer absorb these losses. Some have left, some are leaving. Lenders will no longer support the development of affordable housing in the district. This fiscal year, the Housing Production Trust Fund support that should have gone to developing new affordable housing went instead to keeping existing projects on life support. That shift was necessary as 22,000 units representing $460 million of the district government investment are at risk of foreclosure. Evictions must be rare but possible. If it's not, we lose much of our affordable housing stock to foreclosure. Our affordability covenants will be lost forever, and the ability to address non-payment of rent by some imposes additional burdens on those who are paying rent, including making it harder for landlords to fund necessary ongoing and preventive maintenance. This legislation provides a necessary intervention by allowing judges to keep cases moving, limiting providers' losses, and allowing them to turn around units to rent-paying tenants. It also protects the integrity of ERAP by requiring applicants to document their eligibility and revising the definition of qualifying emergency situation to allow limited ERAP funds to go to families who need it most. ERAP was always intended to prevent eviction for families experiencing time-limited emergencies, not to delay eviction for families for whom rent is chronically unaffordable. The new definition here returns ERAP to its original purpose and will make every dollar go farther to keep more families housed. The committee print also supports eligible tenants by incentivizing landlord cooperation with the ERAP application process and allowing families who never had a chance to apply for ERAP during their eviction cases to reschedule their evictions one time to allow them to do so. The print incentivizes landlords to work with ERAP providers by giving tenants a rent waiver defense in their eviction cases. If a landlord does not comply, the rent that would have been redeemed by a successful ERAP application will be waived. Overall, this legislation realigns the policy incentives around ERAP to protect both affordable housing providers and eligible tenants. I'm so grateful for the legal aid practitioners, tenant advocates, and affordable housing providers who worked with the committee to arrive at a compromise that meets residents' needs. Everyone came to the table and everyone offered ideas that made this legislation better. I was also pleased to see that the emergency version of the legislation already in effect has allowed the eviction process to operate more fairly and efficiently without leading to the denial of more applications. The evidence we have so far shows that this legislation will shore up ERAP and our courts without jeopardizing fair access to the program in the context of the resources that are devoted to it. Finally, I want to acknowledge that working on this legislation came with nothing but hard decisions. Every eviction is a tragedy. To spare more families from that tragedy, we need more homes to end homelessness for more people and more options like shallow rent subsidies to make housing more affordable for more of our residents. Precisely because only housing can end homelessness, ERAP cannot address the district's need for more housing and greater affordability. It was never meant to do so. The families with time-limited emergencies that need ERAP now, need it desperately, cannot wait for support. This legislation will get it to them, and it will get it to them faster. I also know that families for whom housing is chronically affordable cannot wait for the longer-term solutions the district must provide. While ERAP cannot fix the district's affordability crisis, the council can make it a more effective piece of our housing ecosystem by allowing it to achieve its intended purpose and by building around it the housing and supports we need. Is there a discussion? Councilmember Parker.
Thank you, Chairperson Fruman. And I want to first congratulate you and your team. I thought the markup, or the committee print rather, was compelling and well put together and made the case for the crisis that the district is facing. And the headline for me is, as you underscored, our affordable housing stock is at jeopardy. And every dollar that the district has invested in affordable housing to date is in jeopardy. And we know that, as you also mentioned, every eviction is a crisis. I think unfairly the council has been characterized by some as wanting to make evictions easier. And instead, I would refrain that and say we are trying to right-size the relationship between tenants and landlords in an effort to save our affordable housing stock. What those accusations that I've heard underscore is that there is still more needed, that this bill doesn't address, and that ERAP was never meant to address. ERAP is not an end-all be-all measure to address every financial or housing need for residents. And I think it's important for the council to continue to do work in that space. So with those things out of the way, I did want to flag a few things that some of which I have questions about. I think there's a suggestion, and that you haven't made the suggestion, Chairperson Fruman, nor has your committee, but I think there's a suggestion out there by some that we are in this crisis because people are gaming the system. To me, it is akin to the welfare queen narrative. And I just want to also take this moment to push back on that. Yes, there are those that are gaming the system, but we know many people are struggling to make ends meet. Nearly half of Americans are living paycheck to paycheck. And when you have a very expensive city like DC, it is not surprising that people are one paycheck away or one crisis away, one incident away from eviction. So I just think that is important to level set. Two, I know there has been a lot of discussion around the definition of emergency. I align and agree with the committee print, and I think it's fair that individuals should have to provide documentation to support their they're needing emergency relief. There are two areas that I have concerns about. There's one where we put a 30-day limit for landlords to engage or produce paperwork in order, or if they don't, the back paid rent is waived, if I understand the committee print. I would love to just understand the rationale why we landed on 30 days. While I don't disagree with the premise of putting a time limit, I'm not convinced that 30 days is sufficient. If I take a mom and pop landlord that may have a dozen tenants, it is not unforeseen that they may have multiple individuals going through this process. And so I just am not convinced that 30 days is the right time, and would love to see if we can expand that. The second is this idea that we will stay in eviction if someone applies for ERAP as long as their application is pending. I believe that is where the committee print landed. But right now we know the ERAP portal is only open once a year. And in effect, that means one day. And in this year, it meant 6 hours before they closed it. And so to me, that seems like not the most equitable application, because if I am facing eviction at that moment, great, I may be able to get my application in. But if I'm facing eviction in June, I'm kind of out of luck because there's no application for me to apply. More importantly, I think we need to, like we did with our summer programming at DPR, rethink the application portal with ERAP. It is a first comes, first served process. It is often exhausted within hours. And that leaves many individuals who rightly have emergencies left without an opportunity to apply. And so while I know this isn't the right place, I do want to just put on the record that I would love as a committee to work with DHS to explore a lottery process where everyone applies and then they kind of shuffle the applications and then determine who is eligible, because it just doesn't seem fair that a mom or dad who's working multiple jobs, who can't sit at their computer at the right moment, at the right time to apply, might not get the access to these funds. So I know I said a lot, but I would love if you could just speak to the 30-day limit for landlords providing documentation. And I would love if the committee would be willing to expand that or offer a little bit more flexibility there.
So starting with the 30 days, and then I will get to the special scenario where an eviction might be rescheduled. On the 30 days, the burden on the landlord is to provide very few documents. And actually, they are documents that essentially need to be provided for an eviction case anyways. So the idea that there would be a prompt turnaround required for documents to be submitted, and 30 days is, our view was that that was a generous amount of time given the low burden of providing the documents. And we're trying to get to a place where you can't use ERAP necessarily to avoid eviction if it's not going to be the solution, but also having a burden on the landlords to cooperate in a setting where ERAP could avoid an eviction. And so it's a balance there. And I said in my remarks, every decision, every point raised a difficult decision. I think that the 30 days is a reasonable one. Now, on the rescheduling of an eviction, I want you to think about where that comes up. So this is a case where somebody was delinquent with their rent. The landlord brought an eviction process. It went on for months. And we don't want it to have to go on for too long, but it's going to go on under any circumstances for a number of months. That tenant never had the opportunity to apply for ERAP, but the ERAP portal opens in that process and they apply. Now, in order for it to remedy, for them to get a postponement of their eviction at that point, that ERAP application would have to cover the full delinquency. And that would mean that the tenant has been keeping up with their rent in the interim. Otherwise, that delinquency grows into something that can't be solved for. So it's a very, very limited circumstance where this becomes an available avenue. But for that tenant who faced an eviction after the ERAP portal closed and they never had an opportunity, and then it opened and they've kept up on their rent, why wouldn't we try to give them a pathway? So that's the kind of balancing. The pathways that we've created are necessarily limited because the big picture is that we are trying to make sure that ERAP is used for those very special circumstances where it can fix the problem. Certainly.
Thank you for being generous. I would just say on that last point, I support it. I'm glad we have that in there. What I'm speaking to is the fact that we only have one application that is exhausted in hours is unfair to everyone else that may need help throughout the year. I would love DHS to explore perhaps having 2 application portals. The clarifying question I have on the 30-day documentation requirement for landlords, is that 30 days from the application? Is that 30 days from when the third party organization reaches out to request? That's unclear. And I get the thoughtful balance that your team put into this. I just am thinking about those small landlords who may have multiple tenants at once going through this process and realizing that 30 days may put a strain. But thank you again for the time.
All right, well, we can continue to follow up on the number of days and we can, have a conversation between now and a first vote. I do think that it, in practice, is, given the documents that are required, that it is a generous amount of time, but let's continue that conversation. Councilmember Henderson.
Thank you, Councilmember Permit. I do have a couple of questions sort of following up a little bit from what Councilmember Parker was saying. I'm hopeful that you can clarify in terms of so let me back up. This is a bill that we voted on in emergency on a couple of occasions. There are some new provisions that are different. So my questions are faced with some of those new ones. One of the new provisions is with regard to the housing providers who are not compliant with the ERAP application process. Can you clarify in terms of the bill terminology around the court shall require, or it allows for the court may require? Because I feel like a may versus shall is an important distinction here.
Can you point to me where you're talking about?
I don't have the
Yeah.
specific number. I'm saying for this particular portion, my understanding is that while the bill allows for the court to order landlords to comply, we are not saying that a landlord must, or that the court must require it. Does that make sense?
Yes.
So I will give an example. We received an email, or I got an email today from a landlord. I think the tenant owes over 30 grand in back rent. I understand at that particular stage in the game, if I was a landlord, I'd be done too, where I don't want to participate in the process. I want to be able to move this tenant along so that I can get someone else who is going to be, timely in their rents, et cetera. In that particular case, that individual, would the court require them to participate in the ERAP process? Now, I'd imagine because it's over 30 grand, probably not, because ERAP would not cover the full amount. But I think we need to be very clear for landlords, particularly ones who have been dealing with delinquent tenants for quite some time, that this provision is not to elongate the process and require them to participate in a process that, number one, is not going to make them 100% whole, and 2, it's just going to delay the inevitable. That makes sense.
Right. So, and on the rent, this goes to the rent waiver defense, I
Yeah,
think.
yeah.
And so I think important to recognize what the rent waiver defense does and doesn't do, which is it creates a waiver of the rent that might have been paid through ERAP had you cooperated. So it doesn't say that $30,000 delinquency gets washed away. It says that 5 months of that might get washed away if the landlord has not collaborated in an ERAP application.
Mhm.
And the whole goal of everything about this legislation is not to get to a place where we have those $30,000 delinquencies. I think that the requirement to send in a W-9, send in a rent ledger, and once in this whole process, and over the $30,000 delinquency, it would have happened at some point along the way, for the landlord to have to expect the landlord to collaborate. Yes, there will be some settings where the landlord says, this is a doomed process. It's not going to solve it. If the burden were large, I would be troubled by it. But the burden is very modest, and having the requirement in other settings where last year 700 applications were denied because landlords didn't provide the information, I think it's only fair to tenants to have an incentive, to make sure we have an incentive that doesn't slow the process down, but that creates an incentive for the landlord to cooperate.
I think that's where the concern, hearing from landlords and housing providers who have been dealing with very large rent arrears, is that they're not looking for something to slow down the process. And so that's why I'm asking if we can clarify that that's not the intent here, is to slow down the process. And even in the question that Councilmember Parker asked around, if you have a pending rental application, I think it's important to clarify that even if you had a pending ERAP application, this would only apply if the amount owed would be covered completely. Does that make sense? So like I feel like we're getting lots of pushback because there is an assumption that these new provisions is going to elongate the process that is already long.
No, and I hear you on that. And part of it is, so the only way in which an ERAP application can save the day is if it will cover the full amount. And so that's just a fact. Now, you don't know that until you have the landlord participating in the ERAP
To provide the
application,
ledger and
to provide the modest information to do that. Now, the way in which the defense comes up is, in practice, it would come up at trial, and that doesn't slow the process down. It's a defense that's raised, and it could be that the court says, you know what, you got a $30,000 arrearage. You're going to be evicted, but the amount that you're going to continue to owe that will dog you is $20,000, not $30,000, because the landlord didn't cooperate earlier in the process. A different way in which it could come up is in a motion for summary judgment, where the tenant says this eviction fails because there's no dispute of material fact and the landlord didn't comply, and I would have been able to fully cover my arrearages if the landlord had complied. And if they lose that motion for summary judgment, then the case is over before it goes to trial. So it doesn't, as a practical matter, slow the process down. It is certainly not our intention to slow the process down. It is our intention to have some incentive for landlords to comply with an ERAP application, because we have too many places where they do not. And if the burden on them were giant, that would be one thing, but it's not. So we can continue to talk about this and make sure that we've addressed these issues. But I do think that we've addressed these issues, and the purpose is not to slow things down, but to create the right incentive structure.
Thank you.
Councilmember White.
Thank you, Chair Fruman. I appreciate you marking up this bill. I want to continue to balance and correct narratives. There are not a city full of people gaming the ERAP system. There are some people who do, all right? This is not a silly city full of terrible landlords. There are some terrible landlords, right? So I think we just kind of want to, be honest about the facts. The ERAP legislation, really growing from the emergency that we passed late last year, makes permanent this bill, which really attempts to balance things with respect to ERAP and evictions. Both sides of this equation have to work, or it falls apart. A reminder, and this has come up a few times, ERAP is for people who have a true emergency and who can pay the rent going forward if they get ERAP. So it's really a narrow universe of people for whom who should be getting ERAP at this point, especially after the emergency legislation. So this bill does what many folks have asked us to do. I have heard some concerns from landlords about burdens, which I'm not convinced about at this point. So if I'm a tenant in Chairman Fruman's building, and I apply for ERAP and I say, this is how much I owe, this is where I live. Well, that has to be verified by somebody, right? And so the idea that we ask landlords to submit a rental ledger and a W-9, it does not seem to be a tremendous burden. I'm not sure why they also need to submit IDs and proof of social security numbers. That's not in law. And so we may want to work with the agencies on that. But this burden is not huge. And so I think this bill moves us to a very good place. I think any changes get people nervous because things in the rental market have been difficult for some time. But I want us to take a breath and really look at what these requirements are. They are not, in my opinion, a burden. We have some time before first and second reading to talk through that. Like Councilmember Parker, I have some concerns about the provision allowing people who missed the opening of the portal because for me it's somewhat circumstantial, depends on by how much they missed it. I want to make sure that's a real defense and not something that anybody could claim as a blatant defense. So I appreciate the work that you've done on this bill, Chairman Fruman. I look forward to voting it and moving forward. There still are some opportunities for conversations if there are things we need to tweak, but I think we're in a good place today. Thank you, Chairman.
Thank you very much. I'll just react for a second and then I'll get to you, Councilmember Filter. On that, Councilmember Parker raised the idea that the portal should open more than one time a year, and I think you're getting at that. And in practice, it is a lottery. Like some people, the windows open, and some people, the windows never open. And so the opportunity for somebody for whom the window was not open before their eviction, but opened in the middle of their process and they had an opportunity to do it, if it can solve the problem, giving them that opportunity to solve the problem seems fair in an unfair world in which the portal is open for some and the portal's not open for others. That doesn't mean just because the portal was not open for some that we shouldn't try to allow those for whom it was open the opportunity to be saved by this program if it could save them. Councilmember Filter.
Good morning, everyone. First and foremost, I want to thank you, Committee Chairperson Matthew Filman, and committee staff for hosting this morning's markup hearing. There are a number of bills before us today, particularly Bill B 26-0046, the Emergency Rental Assistance Reform Amendment Act of 2025, introduced by Chairman Mendelson. As alluded to earlier, this bill aims to provide a vital fix to the ERAP program, which would, among a few things, clarify the definition of a qualifying emergency, improve and streamline documentation requirements, and provide more discretion to our courts as they sort through and close out cases pertaining to pending ERAP applications. We all have seen the devastating impacts of COVID-19, and in many ways, we're still recovering. While many policies were put in place to provide immediate relief to residents, such as enhancing emergency rental relief programs, unfortunately, given the fiscal climate coupled with the districts being on the verge of losing a significant amount of our affordable housing stock as a council, we must now take a closer look at the unintended consequences of keeping these policies in place beyond their life cycles. So I'm happy to support B dash, or rather B 26-0046, as it signals a good first step in revamping our affordable housing system in a manner that balances the needs of both tenants and landlords. We want to signal to investors that DC is still a great place to invest in affordable housing while also ensuring that residents have access to safe and affordable housing options. So I just want to thank you. And with that, is turn it back over to you.
Really appreciate it, Councilmember Felder. We don't have to be limited to one round. Anybody have anything else? All right, seeing none. I move the committee print and report for B 26-0046, the Emergency Rental Assistance Program Amendment Act of 2025, with leave for staff to make technical and conforming changes. All those in favor, please indicate by saying aye.
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 Aye. All those opposed indicate by saying no. In the opinion of the chair, the ayes have it and the motion passes. I will say the motion passes. There were questions. Some of them go to the agency. Some of them go to a desire for an even clearer understanding of the backdrop. This is a step in the process. It's not the end of the process. And those discussions can proceed between now and first vote and between first vote and second vote. But thank you very much for helping us take this first step forward. Okay. The next measure on the agenda is Title I of B 26-0164, the Rebalancing Expectations for Neighbors, Tenants, and Landlords Act of 2025, also known as the Rental Act. B 26-0164 was introduced by Chairman Mendelson at the request of the mayor on March 3rd, 2025. Only Title I of that legislation was referred to this committee, while other titles were referred to the Committee of the Whole and the Committee on Housing. Title I of the Rental Act is nearly identical to B 26-0046, which the committee just marked up. There's therefore no need for Title I to be included in the final version of the Rental Act legislation. Accordingly, the committee print strikes Title I of the Rental Act in its entirety. Doing so will allow the Rental Act to keep moving through the council while allowing B 26-0046 to take effect before the expiration of the temporary version of that legislation in July. Is there discussion? Councilman Parker.
This is a question for understanding. I totally agree with the committee print that we should not strike the data requirement, but are we actually getting the data? Or where does the data live?
As you can see by consulting from my committee director, we believe it's on LIMS, but we'll check and get back to you.
Got it. Okay, thank you.
Any other questions, comments? Okay. I move the committee print and report for Title I of B 26-0164, the Rebalancing of Expectations of Neighbors, Tenants, and Landlords Act of 2025, with leave for staff to make technical and conforming changes. All those in favor, please indicate by saying aye. Aye.
Aye.
All those opposed, please indicate by saying no. In the opinion of the chair, the ayes have it and the motion passes. We will continue with 3 nominees to the Board of Library Trustees, and I'm going to move them en banc without objection. Okay. PR 26-0118, the Board of Library Trustees Antonio Williams Confirmation Resolution of 2025 nominates Antonio Williams to his second and final term as a member of the Library Board of Trustees. Mr. Williams, a Ward 4 resident, was originally confirmed to the board in 2019 and was elected to and currently serves as chair of the Board of Trustees. Mr. Williams currently works as Vice President of Local Government affairs and advocacy for Comcast NBC Universal. His extensive professional and nonprofit volunteer experience provide him with knowledge about technology policy, necessary skills for working with municipal governments, and connection to the needs of diverse communities combined make him a valuable asset to the board. Based on his background, experience, and leadership throughout his first term on the board, I believe that Mr. Williams should be reappointed to the Board of Library Trustees. PR 26-0119, the Board of Library Trustees Andrew Trueblood Confirmation Resolution of 2025 nominates Andrew Trueblood to his second and final term as a member of the Library Board of Trustees. Mr. Trueblood, a Ward 8 resident, was originally appointed to the board in 2022 and is currently serving out the remainder of an unexpired term and currently serves as chair of the board's Facilities Committee. Mr. Trueblood is the Urban Planning, State and Local Policy and Housing Advisor for Trueblood City and Director of the District of Columbia and was the Director of the District of Columbia Office of Planning until 2021. His current and former experiences working in public service for both the district and federal government, as well as his nonprofit experiences and the knowledge about construction and development he brings to the board make him an excellent nominee. Based on his background and experiences and leadership throughout his first term on the board, I believe that Mr. Trueblood should be reappointed to the Board of Library Trustees. PR 26-0120, the Board of Library Trustees Maria Peace Confirmation Resolution of 2025 nominates Maria Peace to her first full term as a member of the Library Board of Trustees. Ms. Peace, a Ward 7 resident, was originally appointed to the board in 2023. She is currently serving out the remainder of an unexpired term and currently serves as the chair of the Contracts Review Committee. Ms. Peace is the owner of the project manager of PMGL LLC, a district construction development company. Her experiences working in the district and across the private sector and knowledge of development, skills in community and government relations, in connection to the district make her a great member of the board. Based on her experiences, the leadership leadership throughout her first term on the board, I believe Ms. Peace should be reappointed to the Board of Library Trustees. And I will add, we scrupulously asked each of the nominees whether they had library cards, and all did. Oddly, the chair of the board claimed that he had more than one because they were used by others in his family, but we'll overlook that for the moment. Is there any discussion? Okay, thank you. Hearing none, I move the committee prints and reports for PR 26-0118, the Board of Library Trustees Antonio Williams Confirmation Resolution of 2025. PR 26-0119, the Board of Library Trustees Andrew Trueblood Confirmation Resolution of 2025, and PR 26-0120, the Board of Library Trustees Maria Peace Confirmation Resolution of 2025, with leave for staff to make technical and conforming changes. All those in favor, please indicate by saying aye. Aye. All those opposed, please indicate by saying no. In the opinion of the chair, the ayes have it and the motions pass. One more coming around the bend. Finally, we consider the Committee on Human Services second staff appointment resolution of 2025. This resolution appoints Emily Shaney to serve as legislative assistant for the Committee on Human Services. We are excited to have Emily join our team and to see her lead our work with ACTFAMI, MOLA, and MOAPIA. the Office of Cable Television, the Mayor's Office of Latin Affairs, the Mayor's Office of Asian Islander and Pacific Islander Affairs. Is there a discussion? Hearing none, I move the Committee Human Services Second Staff Appointment Resolution with leave for staff to make technical and conforming changes. All those in favor, please indicate by saying aye.
Aye.
All those opposed, please indicate by saying no. In the opinion of the chair, the ayes have it and the motion passes. I want to pause just for 1 second. This is my first markup, and we are a few months into chairing this committee. I want to really thank my committee director, Dan Passon, and Elias Benda. We wouldn't have gotten to where we are without them. So thank you very much for all of the work that you have done. The conversation on all of these matters will continue until they're finally passed by the council. But with that, the business before the committee is concluded. The time is now 11:47, and this meeting is adjourned. Thank you.